And just a couple other things to note too. We do have the Q&A function or question function is enabled on Zoom, and so you can put your questions into the chat or also raise hands. But to kick us off, I am Alyn Lancaster. I am the Housing Leadership Manager here with the City of Redwood City. I'm also joined today by Victor Gaitan with the city, as well as Esenia Macias with Project Sentinel. And the three of us will be doing the presentation today. I will give a brief overview of the city's new tenant protection ordinance, and then Victor will do an in-depth review of the ordinance, including the minimum lease terms, just cause eviction protections, and relocation assistance. After the city's portion of the presentation, we will take questions on the tenant protection ordinance. And then we will have Project Sentinel give a presentation on state laws, and then we'll open it up again for questions on both the tenant protection ordinance and state laws. So just to give some background on how we got to where we are today, back in 2018, the city adopted a minimum lease terms ordinance and a relocation assistance ordinance. However, in 2019, the state then adopted what's known as the Tenant Protection Act, which we might also refer to as TPA. And this was a statewide policy that included rent stabilization, just cause eviction protections, and relocation assistance. While this did provide additional tenant protections to Redwood City tenants, it did preempt the city's existing relocation assistance ordinance, which had provided greater relocation benefits to low-income tenants compared to the state law. What this really means is we could not enforce our relocation assistance ordinance for the last 6 years. So starting in 2020, the city worked on developing our anti-displacement strategy. This was a 2-year effort with extensive community engagement and research. And you'll often receive this referred to also as the ADS, but the anti-displacement strategy looked at how the city could improve tenant protections, preserve existing housing that was affordable, and preserve our mobile home parks. This was approved by the City Council in 2022, and staff has been working on its implementation for the last 3.5 years. One of the key recommendations coming from the anti-displacement strategy was to adopt a comprehensive tenant protection ordinance. This would make updates to our existing minimum lease terms requirements, add just cause eviction protections consistent with state law, which in turn would make our relocation assistance requirements once again enforceable. We also spent a considerable amount of time researching and engaging with the community on whether to require landlords to offer tenants a right to return to their unit after a substantial remodel has been completed. Thank you. So in the fall of 2025, the City Council did adopt a tenant protection ordinance that includes minimum lease term requirements, just cause for eviction protections, a right to return requirement for substantial remodels, and relocation assistance requirements. And this did go into effect January 1st, so just a few days ago. And as I mentioned, we'll go over all of these requirements in much greater detail in this presentation. But just to kind of summarize all of that and really kind of the key takeaways and understanding what applies here in Redwood City under the city's ordinance as well as state law. So in that left-hand column is all the state law requirements, and then on the right-hand column is our city ordinance requirements. And so state law does require rent stabilization, whereas the city's ordinance does not. And the landlord still must comply with the state law. So this imposes a 5% plus the change in consumer price index or CPI, or 10%, whichever is lower. So there is a cap on rents between 5 and 10%, depending on what CPI is. State law does not require a minimum lease terms, but the city does. And this is, again, an existing requirement that has been in place since 2018. Both the state and city ordinance require just cause eviction protections, and the types of just causes are consistent between state and city requirements. For relocation assistance, the state law requires 1 month's rent for all tenants, And the city also requires greater relocation assistance for low income and special circumstance tenants. And so I will hand this now over to Victor to continue the presentation.
Thanks, Lynn. As Lynn mentioned, my name is Victor Gaitan. I'm a housing management analyst, and I'll be going over the details of the tenant protection ordinance. So, starting off with applicability, specifically which rental units does the tenant protection ordinance apply to? Before we get into the detail, I do want to point out a little outline of the state of California and the pink text on the bottom right-hand corner that says consistent with state law. You will see this icon on several slides moving forward. And we did this to point out um, all of the different sections within the tenant protection ordinance that are consistent with state law or that almost copy exactly what is in state law. So hopefully a lot of this information is not new to many of you if you've been following state law. So we just wanted to point that out. So, applicability, the tenant protection ordinance generally applies to all rental properties within incorporated Redwood City. We do want to highlight incorporated. The lines for Redwood City, if you've ever seen a map, do get a little blurry between incorporated Redwood City, unincorporated North Fair Oaks, or unincorporated Emerald Hills. So we do just want to make sure that you're aware of where your property lies and whether you're actually within our jurisdiction or the county's jurisdiction. So going back to which rental units does this apply to, there are several exceptions which we have listed on the screen. And so those would be nonprofit hospitals, religious facilities, extended care or adult care facilities, deed restricted affordable housing, housing that's shared with the landlord. Single family homes and condominiums are exempt unless they are owned by a corporate entity or if it's an LLC, if at least one member of the LLC is a corporation, then it would apply to that. Duplexes, if the owner lives in one of the units, new construction if the properties were built within the last 15 years, mobile home spaces, and transient and tourist hotel occupancies. Again, majority of the exceptions are consistent with state law. So I'm hoping this is not new information. Moving on to minimum lease term requirements, landlords must offer tenants a 1 year lease at initial lease up, and 1 year leases are not required to be offered at lease renewals. If you are familiar with our prior minimum lease terms ordinance, that ordinance required a 1 year lease offer at initial lease ups and at renewals. So the biggest difference here with this ordinance now is that we are no longer requiring that landlords offer 1 year leases at renewals. If a tenant rejects the 1 year lease offer, then the tenant and the landlord may enter into an agreement for a shorter lease term as long as both sides agree to the lease terms. That could be a 6 month lease term, it could be a month to month, whatever you both agree to is fine. And then landlords must provide prospective tenants with a notice of rights to a 1 year lease. This is on a notice form that is provided by the city, which is now live on our tenant protection ordinance webpage, what we'll show at the end of this presentation. Moving on to just cause for eviction protections. Again, consistent with state law, landlords cannot terminate a tenancy without a just cause when one, all of the tenants have lived in the rental unit for 12 months or more, or if one or more of the tenants have continuously occupied the rental unit for 24 months or more. So if an additional adult tenant was added to the lease during that period, then at least one of the tenants has to have lived in the unit for 24 months or more in order for these protections to apply. And there are at fault and no fault just cause reasons for terminating a tenancy, which I'll bring over next. So the at fault just causes, again, mirror state law exactly. And so these reasons include non-payment of rent, a breach of the lease terms, nuisance, waste, or criminal activity, subleasing without consent, denying the landlord access to the rental unit, illegal use of the rental unit, or the other reasons listed on the screen. So these are at fault reasons. So if the tenant is at fault of doing one of these things, then the landlord has a just reason to terminate a tenancy. And then we also have no fault just causes. So these are reasons why a landlord may terminate a tenancy that are at no fault of the tenant. And these include an owner or relative move into the rental unit, withdrawal of the rental unit from the rental market, if the unit must be vacated to comply with a law or a court or government order, if the landlord intends to demolish the rental unit, or if the landlord intends to substantially remodel the rental unit. And for all of these, there's specific requirements that I'll be going over in the next few slides. Starting with owner or relative move-in. Relatives include an owner's spouse, domestic partner, child, grandchild, parent, or grandparent. As I mentioned, there are specific requirements within the ordinance, so I do want you to be aware of those. So, in order for an owner or relative move-in to count as a no-fault just cause, the owner or relative must occupy the rental unit within 90 days, providing the notice of termination to the tenant, and then they must continuously occupy the rental unit as their primary residence for at least 12 consecutive months. And if the landlord fails to do either of those, either move in within 90 days or live there for 12 consecutive months as their primary residence, um, then they must offer the rental unit back to the original tenant at the same rent and lease terms, and they must also reimburse the tenant for reasonable moving expenses, which exceed any relocation assistance paid. This language exactly mirrors what is in state law already. Next, for demolishing rental units, there are specific noticing language requirements. So, in the notice of termination, a landlord must include a statement informing the tenants of the landlord's intent to demolish the rental unit and information about the tenant's right to return if the demolition is not commenced or completed. And if the demolition is not commenced or completed, then the landlord must offer the tenant the right to return at the same rent and lease terms that was in effect when the tenancy was terminated. And then there are specific noticing timelines and requirements. Moving on to substantial remodels. Again, there are specific noticing requirements that must be included in the notice of termination. So the notice of termination must include information about the intent to substantially remodel the rental unit, a description of the work and the expected duration of the work, information of the tenant's right to return if the work is not commenced or completed, similar to the demolition requirements. But for substantial remodel, we also require that landlords include information about the tenant's right to return once the work is completed. So that is the big difference between state law and the city's ordinance, is that the city ordinance, the tenant protection ordinance, requires that landlords offer tenants the right to return to the rental unit once the work is completed. So what qualifies as a substantial remodel? And this is the exact same definition as you'll find in state law. So a substantial remodel is a remodel that requires the tenant to vacate the rental unit for at least 30 days, and that involves the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit, or the abatement or hazardous materials, including lead-based paint, mold, or asbestos. And cosmetic improvements alone or other work that can be performed safely without having the unit vacated do not qualify as a substantial remodel. So if the landlord is going to change carpets, flooring, or do any other work within the unit that does not require the tenant to vacate the unit in order for at least 30 days in order for the work to be completed, then that is not a substantial remodel. As I mentioned, the city's tenant protection ordinance does require landlords to offer the right to return once the work is completed. So when terminating a tenancy for a substantial remodel, landlords must offer tenants the first right to return to the unit once the substantial remodel is completed. This offer to return must include a lease with the same rent that was in effect when the tenancy was terminated plus any increases that would have been allowed by the state tenant protection ordinance of 2019 had the tenant continuously resided in the unit, and the same lease terms that were in effect at the time the tenancy was terminated, except for any changes required by state law. And there are also specific noticing timelines that are really important to be aware of when offering the right to return. So once the work is completed, the unit is ready, and the unit is ready for reoccupancy, the landlord must notify the tenant within 10 calendar days and must offer the tenant the opportunity to rent the rental unit. And this notice must be sent to the tenant via certified mail, and a copy of the certified mail receipt and the notice must be sent to the city. Once the tenant receives that notice, the tenant then must notify the landlord of their acceptance or rejection within 30 calendar days. And again, that notice must be sent via certified mail with a copy of the certified mail receipt and a copy of the notice sent to the city as well. And if the offer is accepted, the tenant must then reoccupy the rental unit within 30 calendar days of notifying the landlord, and the tenant must either sign a lease and or pay a deposit prior to reoccupancy. And we did include we're calling a fair rate of return appeals process related to the right to return requirement. So landlords may file an appeal for a higher rent increase if the right to return rental rate would cause the landlord to be unable to obtain a fair rate of return. We're currently in the process of developing guidelines for this process, but the guidelines will generally provide more detail, and they'll outline that landlords will need to provide financial information about the property, including documentation of annual expenses and revenue, information about each rental unit, documentation and receipts of the substantial remodel costs. But yeah, so those guidelines will be coming out in the next couple months, and we'll be sure to notify landlords once those guidelines are available. And the last section I'll be going over is the tenant relocation assistance requirement. Landlords are required to pay relocation assistance to tenants when terminating a tenancy for a no-fault just cause. All tenants are entitled to relocation assistance equal to 1 month of the tenant's rent or a waiver of the final month's rent. It is up to the landlord to decide whether they would provide the 1 month of relocation assistance or the waiver of the final month's rent. Qualifying low income and special circumstances households are eligible for greater relocation assistance under the city's tenant protection ordinance. And landlords will make the payment per rental unit, not per tenant within the rental unit. So as mentioned, qualifying low income, meaning households that make 80% or less of the area median income, are eligible for relocation assistance equal to 3 months of fair market rent. And here in the little chart in blue, we have the low income limits for 2025. These change annually. So these are effective as of April 23rd of last year and will be updated probably around April or May of this year. So for a household of 4, the maximum income that you can make to still qualify as low income is $156,650. And you can see for the household size, the maximum income limits. Now, households that qualify as low income and special circumstances are eligible for relocation assistance equal to 4 months of fair market rent. And to qualify as a special circumstances household, you need at least one member of the household that meets one of the criteria in the box in blue. So if at least one member is 62 years or older, if at least one member is disabled, if at least one member is a child under 18 who is also legally dependent, or if a household has occupied the rental unit as their primary residence for 5 or more consecutive years, then that household, if they also qualify as low income and they meet one of these criteria, then they qualify for 4 months of fair market rent relocation assistance. And so I mentioned fair market rents. Fair market rents are standard rents that are published by the U.S. Department of Housing and Urban Development annually. Again, you'll see these are effective as of October 1st, 2025. So this will be updated probably around October of this year. So for a one bedroom, the fair market rent for 1 month is 2,977. For a two bedroom, 3,604. So this might differ from what your actual rent is, but because these are standard rents that are published by the US government, we'll be using these to determine the fair market rent calculation. And here we have a sample relocation assistance calculation to kind of help illustrate what this might look like. So in this example, a tenant that rents a one bedroom unit for $2,500 receives a notice of termination for a no fault just cause. The landlord must pay relocation assistance equal to 1 month of the tenant's rent, so the $2,500 within 15 days of the notice of termination. Then, if the tenant applies for the city's tenant protection ordinance relocation assistance and qualifies as low income, then they would be eligible for 3 months of fair market rent. So 3 months times the 2,977 that we showed on the fair market rent page would equal 8,931. But since the landlord has already paid the tenant $2,500, that would be subtracted from the 8,000. And so the landlord would only have to pay the tenant an additional $6,431 as they've already paid the tenant the 1 month of rent. And we're happy to help anyone with this calculation if you need assistance. And I know it can be a little confusing. Tenants that are interested in applying for greater relocation benefits under the city's tenant protection ordinance must submit a relocation assistance application to the city. This application must be submitted within 15 calendar days of receiving their notice of termination. And the application will require proof of household income. This application is already available on the city's tenant protection ordinance website. Once the city receives the application, the city or a third-party provider will review the application and determine the tenant's eligibility within 10 business days. And if the application is denied, tenants may file an appeal with the city. And so here is the link or the URL to the webpage we mentioned. That's redwoodcity.org/CPO. On that webpage, we have information about all the different sections of the ordinance, a link to the ordinance itself, a link to this presentation in both English and Spanish, and towards the very bottom of the page, we have a link to all the different forms that we mentioned. And we'll be adding forms in the next few months, including the guidelines once it's available. So I would always go back and reference this webpage for any updates. Here we also have our contact information for Redwood City housing staff. You can email us at housingrwc@redwoodcity.org, or you can call me. That's my direct line. It's 650-780-7303. You can call me or leave me a message, and I'll be sure to get back to you as soon as I can. We also included Project Sentinel's information here, although they'll be presenting next. Project Sentinel is a great resource that is free to both tenants and landlords. If you have any questions about your housing situation, issues that might require mediation, they're really a great resource. So we highly recommend you reach out to them. So for now, we'll open it up to a couple of questions. And then after a couple minutes, we'll stop the questions and move it over to Project Sentinel so they can go through their presentation. And once they're done with their presentation, we'll open it back up for general questions, either to the city or Project Sentinel.
Thanks, Victor. So if you do have questions, please feel free to type them into the question and answer portal, or you can also, I believe, raise your hand and you can ask your question live. Um, I think Jesus had a question about the tenant relocation assistance calculations, and I'm wondering, Victor, if you could go back to that slide and um, maybe go through it one more time, because this is just an example. Um, where we were assuming the tenant's rent for a one bedroom is 2,500. But if, for example, the rent was higher at 4,000, the landlord would pay 4,000 initially, and then if the tenant qualified as low income, they would pay the balance. In this case, would be at 4,900. So just wanted to highlight that this is just an example. That first payment should be based on the tenant's actual rent, equal to 1 month's actual rent.
Correct, and that could be a waiver of the final month's rent if the landlord chooses to do that. And if it's a household that does not qualify for the city's additional or greater relocation assistance, then it would just be the 1 month of rent for that household. Yeah, so this is just a sample. The 2,500 was just a sample number.
So there is a question from Mark, and I'll read this. Is there a form regarding notice to a tenant of their right to relocation expenses if they qualify as low income? Something that can be included with a termination notice. Yes, there is, and I will actually put that into the chat
And it is
for you
also
as
on
well.
the TPO webpage.
Yes.
Yeah, so the three forms that we have available on the TPO webpage right now are the notice of minimum of right to minimum lease terms, the notice of tenant's right to relocation assistance, and the relocation assistance application.
I think we'll have Project Sentinel. Oh, sorry, there's one more question. Um, at what point is the tenant entitled to the relocation assistance? After 12 months or sooner? So, I can take it.
Mhm.
I can answer this one. So, relocation assistance is only provided if it for a no fault just cause termination, and a tenant does have to have lived there for at least 12 months to qualify for the just cause eviction protection. So, um, and maybe Victor, you can go back to the slide with the 12 months first 24 months. If all the
Yeah.
same tenants have lived there for 12 months, then they would qualify for the just cause eviction protections. And if it's a no fault just cause termination, then they would get relocation assistance.
This one. No, you're not seeing anything. Got it. There we go.
Yes.
Mhm.
And then someone did ask, what exact forms must we include upon lease signing? You do need to have provided the tenants with the notice of minimum lease terms to prospective tenants. While nothing is mandatory to include in a lease, we do recommend including as much information about the city's ordinance as part of that. And I think Asenia will talk about kind of best practices when it comes to leases in her presentation. But at lease signing, the only thing that's mandatory is that prospective tenants are given the minimum lease term notice. And I will also, again, that's on our website, but I will put it into the chat as well.
And then the notice of tenant's right to relocation assistance should be included with the notice of termination. And then Mark has a question. Is there a time period for tenants to provide proof that they are low income? So yeah, so that let me go to the location assistance applications. So The proof of household income must be included with the application submittal to the city. So within 15 calendar days of receiving notice of termination, you must provide proof of household income with the application. And
And
then
then Victor, oh, sorry, there's a
uh,
question about are townhomes exempt if not owned by a corporation?
yes, so I'll go back to the applicability slide. There we go. So townhomes are treated like condos for the purposes of this. So yeah, single family homes and condominiums that are owned by an individual owner are exempt. Yep. Should we move on to Project Sentinel's presentation and then come back to the questions after? Okay. All right, Sunny, it's all yours.
Good afternoon, everyone. My apologies that my video is not working today, but I'm glad that you guys are able to hear me. We're gonna go right into our presentation here. Project Sentinel manages the dispute resolution program for the City of Redwood City residents and housing providers, and our mission's to develop and promote fairness and equality of housing opportunities for all persons and to advocate peaceful resolutions of disputes for community welfare and harmony. A little bit about Project Sentinel. We have three different departments. I'm presenting today on behalf of Tenant Landlord, which we also call dispute resolution. We manage the Redwood City Hotline to educate folks on their rights and responsibilities. We sometimes, depending on the caller, it's their choice if we can try to help them conciliate with the other opposing party. If that's not successful, we also can set up and coordinate a formal mediation, which includes providing case management and sometimes referrals. This information in this presentation is only for educational purposes, and we do not provide legal advice. Two important things about what we do, conciliation and mediation are different. Basically, our case managers who manage the hotline who conciliate are part of the negotiation process because the counseling is kind of gearing them and their rights on what the subject matter is. Whereas mediation, we set up the mediation, and the day of mediation, it's a third party neutral who knows nothing before, never spoke with the party, does not know them, and really helps the communication and the parties try to discuss their differences and reach some sort of resolution. So going into the Tenant Protection Act, I will refer to it as AB 1482. There's four components to it, which are really important. The first one is noticing requirements. Every landlord in California is actually required to notify their tenants if they're covered or not. So if they're not covered, there's a specific paragraph that should be included in the lease saying they're exempt. And if they are covered, there's another paragraph that should be included in the lease agreement. And when folks call our hotline, we do provide them with that paragraph with both of them. It's called the notice language sections. Um, if a landlord does not include it in a lease agreement or a renewal, what happens is that it can make things a little bit complicated. And if at any point, usually some landlords who don't include it will do like an addendum, which is fine. But The main thing is after July 2020, it should be included in on all new lease agreements. Otherwise, if the tenant is not notified, then they're presumed to be covered until the landlord properly notifies them. The second component is the rent cap. So every year the CPI changes, the Consumer Price Index, and it varies within the state of California. Um, the most important thing is in the area that we cover, so San Mateo County, San Francisco County, Marin County, Contra Costa, San Mateo. Um, the rent cap's a little less than the state. And so it's really important to know which one applies. For Redwood City, it is currently 6.3%. But for all other counties, it can be up to 7.7%. And so another thing I learned too is that the percentage that is published in April is what goes into effect August 1st. So the CPI changes every August 1st, and we typically update our flyers right before that. As you may notice on the state CPI website, it doesn't get published immediately for the month of April. We sometimes see it as late as June and early July. The third component to AB 1482 is termination notices. So evictions just cause. So a termination notice is actually the first step to a housing provider, any housing provider, to ask somebody to move out. If that is not complied with, assuming that it was properly given, um, either that or, for example, non-payment of rent, that's what triggers an eviction. An eviction is not a termination notice. An eviction is where a landlord has provided a proper notice of some sort, either 3 days, 30 days, 60 days, or 90 days, and it was not complied with by the tenant. Therefore, they went to court and filed what's called an unlawful detainer, another word for eviction. So I will refer to it as terminations, and they're broken down into two subgroups. So, like the Redwood City Ordinance that Victor covered. The first group is just cause. It's basically a reason. Why are you asking a tenant to move out? Um, and it's either the tenant's fault or not the tenant's fault. Every notice from the landlord must be in writing, not emailed. It needs to be in writing and properly served to the tenant. Now, there's some exceptions here. Um, when a notice is given to a tenant to move out and it's not their fault, examples of that can be like maybe the owner's moving in a family member, or maybe they're intending to remodel the unit substantially that requires permits, or maybe code enforcement has tagged the unit to be not habitable, for example. That's where the relocation comes in. And so when landlords give tenants termination notices to move out for no fault, it's actually required under the TPO that um, the landlord cite how they will provide the relocation to the tenant. Um, if it usually what we commonly see is that the last month is waived. But if that's not the case, landlords are actually required to provide the relocation payment within 15 days of serving a termination notice. And so, again, these are things that we educate everyone on when they call our hotline if it applies to them. The fourth component to this is going to be the relocation. And so, yeah, it's really important for at-fault termination. Say, for example, the tenant owes rent, relocation wouldn't be required in that situation. Or if maybe the tenant has violated the lease and has received multiple notices to correct the issue, but it continues, then the landlord can file an eviction alleging at fault. So it can vary on the type of notice and depending on Now, it can be a little bit confusing too because the Redwood City Ordinance is more protective than just the 1 month that the state requires. And so the most important thing or takeaway, I should say, from this is these ordinances both apply, the city and the state, and everything applies. And the one that supersedes always is going to be the one that provides the most protection. So although Redwood City doesn't have um, a specific rent cap, the state applies there. However, the relocation is more protective. So that would still apply. Everything applies. Next slide, please. So I was mentioning earlier, there's two reasons for no fault, and this kind of provides a little bit more detailed information. So when a landlord gives a termination notice that they're going to move in the unit, it's required that they move in within 3 months and that the family member stays there for at least 12 consecutive months. Um, the tenants are also allowed to be notified of the relationship of the person moving in to the owner. Um, and they can also request proof. So the 90-day rule and 12 consecutive months is really important because if not, then the tenants have the right to move back into the unit at the same rent and at the same terms, and the landlord must cover the moving expenses. So it's always a good practice to, when a housing provider does give a termination notice, that it's done so in good faith. The second one here is for demolishing or remodeling units. So in an example of a termination notice, whether it's 60 or 90 days, it must include, for example, the like a declaration or statement from the owner with an explanation of why they're wanting to remodel the unit. Um, it must also state that they will re-rent the unit to the tenant at the same rent and terms. Um, and also the completion dates as well as the description or estimated time it will take. And most importantly, copies of permits should be attached to the termination. And then again, notice to the tenant that they may reoccupy the unit after the remodel. So this also comes into play too. I just want to point out when there probably is an habitability issue. Although a landlord may not be asking someone to move out, um, these requirements still are in place. Um, Now, the Tenant Protection Act applies to folks who've been living in their unit for 1 year or more. But say, for example, maybe an individual moved out and someone else moved in. If both individuals have not been there 12 consecutive or 24 consecutive months, they are not covered because the terms have changed. So that's something I do want to point out. Next slide. This is a chart I included from the State of California Department of Justice website. And this is how I was able to cite on our flyer the rent caps. But as you will see on the right side, which is page 2 in the blue box, under San Francisco area, San Mateo County does fall in that area. And it breaks it down by year. So currently it's 6.3%. But in all other counties, for example, like Stanislaus County or Merced County, for example, they would be under the 7.7%. So that's the difference. And then common topics that we see or that we usually get during the calls we receive are pretty much everything from habitability to maintenance and repairs, mold, deposit calls, abandonment of property, rent increases, or just general tenant landlord information. How can I access the ordinance, or what forms do I need? Or I moved out and didn't know I was supposed to get my deposit. I've been waiting months. Sometimes there are neighbor to neighbor disputes, fences, barking dogs, common areas, sometimes shared utilities. Next slide. And then this is another flyer our agency has. We just kind of put it together because there's so many new laws, so it's good to just kind of have them listed for everyone. But I'll start on the left side. The first bullet point is the bit.ly link where you can find the CPI information. The second one is Assembly Bill 2801. So security deposits as of July 1st of last year, for landlords who do deduct monies from someone's security deposit, they're actually required to take before and after photos to show the change and the difference of whatever damages they're alleging, unless it's unpaid rent, of course. Um, and then effective in April, um, nothing has really changed besides the fact of the photos. The 21 days is still a requirement to provide tenants with an itemized statement. And in addition to that, um, landlords should provide always copies of invoices, receipts, work orders, contractors' information, or vendors. The tenants do have a right to verify and contact the people who did the work. And sometimes that's not provided, so the more documentation, the better. The other thing is security deposits were limited to 1 month's rent unless a landlord owns more than 4 units and they're not a corporation. Um, and then the third one is going to be application screening fees. So usually I believe it's like within 10 days or so, maybe a little bit after that. I'm not sure what reasonable means. You'd have to review the civil code. But AB 2493 actually requires for housing providers to return the application screening fees to the applicants. Um, and so in a little bit more detail, um, they need to return all application fees to all the applicants who were not selected, basically. Page 2 on the right side, AB 2747, positive rental payment reporting. This is something that should be cited in the lease agreement with properties with less than 16 units, or if there's more than one building. It's optional, and it's basically the tenant can basically check the box if they want their housing provider to report their rental payment history to the credit bureaus. SB 611, so there's paying rent. There should not be fees for checks. And there's also not fees for any notices. So this prohibits charging any fee for payment by check for rent or security deposits. It also prohibits charging a fee for serving, posting, or delivering a termination notice. So this also aligns with the Redwood City Ordinance. If a tenant gets or receives a termination notice, for example, there should not be any fees for a housing provider serving that or posting it on their door or giving it to them in person. SB 1051, victims of domestic violence. Landlords are required to change the locks at their own expense within 24 hours of receiving documentation that the household member has been a victim of abuse. If the landlord fails to change the locks, the landlord must reimburse the tenant within 21 days if the tenant changes the locks. And then for the purpose of tenant screening, the landlord is prohibited from making an adverse action against a prospective tenant for having been a victim of abuse or violence. And then the last one here, Section 8 discrimination. It's illegal for any landlord to say that they don't accept Section 8 or housing vouchers. Landlords must base income eligibility on the portion of rent paid by the tenant. So, like in a lot of rental ads, you'll see you must make 3 times the rent. Great. But if it's someone who's a voucher holder, it needs to be 3 times of their portion of the rent, for example, not the rent the landlord's asking for. And then landlords must also reasonably consider alternative evidence of their ability to pay instead of an applicant's credit history. So, although someone may have a bad credit history, if they have other sources of income, that can be something that can be acceptable, for example. Next slide. A fixed term lease versus month to month. This is one that's really important because a lot of people think verbal is not a lease. Obviously, a fixed term lease has a start and end date, and in lease agreements, some end, and the expectation is that the tenant will move out. But if there's not an end date, some will say it continues automatically month to month. Whereas month to month examples can be like verbal agreements or maybe leases that have expired that were not renewed, or people who just pay rent on a monthly basis. Um, Housing providers can change the terms, of course, with providing something in writing. One thing I do want to point out too is that if there's not a written lease that exists, and say, for example, a tenant needs verification, the landlord has 30 days to put something in writing of what has been being practiced. The tenant lives at this address, they've been paying X amount of rent, they moved in on this date. So basically, a lease must be drafted as to what the practice has been, for example. Next slide. This is our this comes actually from the California Nolo Press Book. It's the landlord's law book of rights and responsibilities. But it basically cites what a habitable unit is: proper plumbing, electrical, windows, doors, locks, lack of pests, proper garbage areas, proper floors, stairways, safety, disposal, a working toilet, a kitchen sink, for example. Next slide. Examples of best practices. So always keep things in writing. Um, it's really not good to sign a lease electronically or even in person if you not have seen the unit. Take time to read the lease agreement and fine print. It's okay to tell a landlord, I need time to review it. Um, for housing providers, always request and offer tenants the right to attend and the inspection itself, whether it's a pre-move out or final move out. And then also creating your own checklist as you're doing a walkthrough before moving in and after. And most importantly, taking photos given the new security deposit requirements. For landlords, checking references is acceptable. And for everyone, getting familiar with what your rights and responsibilities are. So Project Sentinel has 5 offices. Our main office is in Santa Clara, but our Redwood City office is in Redwood City. We manage our hotline from 9 to 4:30. We do answer live. Um, we send rent information like the flyers that were presented today by email if you need them, or if you have any follow-up questions or concerns or a dispute, you're more than welcome to call our San Mateo office. And then we have several service areas besides Redwood City. We serve Santa Clara County, including unincorporated, Stanislaus County, including unincorporated, and then individual cities we have contracts with, obviously Campbell, Cupertino, Hayward. We manage the rent registry stabilization ordinance there. We also handle the mediators for petitions, also for Palo Alto, Sunnyvale, City of Merced, City of Richmond, and obviously Redwood City. There's some resources here. So we're not an emergency service and we are not a legal service agency. We provide general information and educate folks on public information, and we provide mediation. Legal Aid Society, Bay Area Legal Aid are agencies that do provide legal service. I know it's based off income, so there is eligibility criteria. Also, CLESPA, which is Community Legal Services in East Palo Alto. Some folks are not eligible for that because they're not tenants or because they're over income. And so in those situations, I would highly recommend contacting the Bar Association, which is rather quicker. There is a fee for a 30-minute consultation, which is less than $50, but it will save you a lot of time from calling around when you may not be eligible for service. And then a few other resources like code enforcement. For homeowners, we do have a mortgage department and housing counseling. We also have a fair housing department that handles discrimination or folks with disabilities who may need accommodations or modifications in their unit or have a service animal, for example. So these are all listed here as a resource for you. And then this is our Redwood City flyer. It kind of talks about our program, a lot of stuff I covered in our presentation, what we do, what is dispute resolution, which is basically mediation. And then it has our contact number and our work hours there.
And Senya, we have a couple questions that came in that I'm hoping you can answer.
Okay.
So the first one is if a rental unit has been vacant and will now go back in the market, does the rent cap apply even though the old rent was a long time ago?
The rent cap only applies when an existing tenant has been living there 12 months or more.
Thanks for that. And then they had another question around AB 2493 around the application fees. Does this mean we must accept first tenant who meets the requirements and we must repay screening fees to applicants who are not selected? Huge burden on landlord. So perhaps you could maybe go over AB 2493 one more time.
Yeah, so for AB 2493, there's a lot of different criteria that comes into play when selecting a tenant, right? Besides income, it can be many other factors. I think the most important thing with that is being as reasonable as you can, looking at all the individuals, checking references, making sure that all the income has been provided. Um, Now, if you choose somebody to rent the unit and it's within maybe 14 days, for example, all the other applicants that were not selected should be refunded their screening fees. So I'm not really able to answer, does it have to be the first one? I think you need to use your best judgment and see what kind of applications come in. But treating them all the same and having the same standard for all of them is what's reasonable.
Thank you. I just want to, if you have any other questions, please either put them into the chat or raise your hand. I know it's a little past 1 and we are more than happy to stay on longer and answer questions. And if not, we hope you have a wonderful afternoon and just want to thank you again for joining with us and participating. And all of these, I recommend going to our website, redwoodcity.org/TPO. That's where you will find all of this information and kind of all the most up-to-date information. So I see another question again around AB 2493. I was under the impression that if you as a landlord publish the requirements, then you did not have to refund the application fee to the other applicants. Is that correct?
The application fee should be refunded, and I would highly suggest that you consult with an attorney for further direction because that can get a little bit tricky. And also use the link or maybe Google the civil code to read a little bit more on that. But The least I can say is that it should be refunded if they're not selected.
And then we have another question. Says if we have a duplex and live in one unit and rent the other, do these rules still apply? So the city's tenant protection ordinance would not apply in that case. That would be an owner occupied uh, unit. So the tenant protection ordinance would not apply, but I believe the TPA, the state TPA would still apply, right, Yesenia?
So duplexes are a little bit tricky. Um, the first thing is if it's owner occupied, then it's exempt, meaning the
Mhm.
landlord lives in one unit, the other one's re-rented. So the tenant should be notified they're exempt. However, if they are both rented out, then they are covered under the TPO.
Yeah, it seems under this question, it would be exempt under both the TPL and TPA.
Yeah, so the it would be covered. So if there's a duplex property that's fully rented out, both units are rented to tenants, then they are covered under these protections.
Yeah. And again, if you do have any questions or anything you can think of after this meeting, please feel free to contact us here. We have our contact information. You can email us or call us, or visit our webpage for more information. And if you do know of anyone else that you think would find this information useful, we do have a couple more meetings coming up. They're the exact same as this meeting. So we have one tomorrow night at 6 p.m. on Zoom. We have one in person at City Hall in the council chambers at 6 p.m. It's on the one, I think it's Wednesday the 14th. And then we have a final one on February 4th at 6 p.m. at City Hall as well. And all this information is also found on the TPO webpage. All right. Not seeing any other questions come in. I think we can end the meeting. So thank you all